there is no discipline I'm aware of that includes choking, which is what this says, or kicking, punching, or slapping. And apparently the reason all this, he brought toys into the bathroom, into the bathtub. That's what this says. Well, choking, when you choke somebody, there's only one reason you do that, and that's to seriously injure or kill somebody. I mean, that kills people when you shut off their breathing. They have to breathe to live.
In Jefferson County, Texas, Rianella Monique Gage appeared before Judge John Stevens on a third-degree felony charge of injury to a child stemming from an incident on March 20th, 2025. An agreement had been reached before the hearing, but before Judge Stevens accepted it, he had something to say about what was in that indictment, and he was not going to let it pass without putting it on the record.
Texas, you committed the third-degree felony of injury to a child younger than 15 years of age. It says by striking the child about the head and body with your hands and feet and choking the child. That's what this alleges. Do you understand what you're charged with here?
Yes, sir.
If convicted of this, you face a third-degree felony of a term of not more than 10 years, less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. Will you be pleading guilty? And then not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fine $500. And this is a form of probation where there would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
I understand.
How do you plead to this, guilty or not guilty?
Guilty.
No, you pleading guilty voluntarily, that is on your own free will, because you are guilty.
Yes, sir.
I'll show you. It's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
No,
without objection. It's admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been good to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided. You're all true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is the pre-sentence report waived here?
Yes, Judge.
Judge, I believe when this first came out, she took some classes with CPS and got those completed. CPS is backed out. The environment she's living in right now, she needs to come back home to mom and the state after discussing and with defense counsel and looking at this, believes it'd be in the best interest for the child that she'd be allowed to go back home to mom. He go back home to mom, sorry. And I know at the time that there was some things going on that we ended up indicting her for. I'm glad we did because I think it straightened a lot out.
Yes.
It's not unusual for children to need discipline. I mean, that's important.
Yes, sir.
But there is no discipline I'm aware of that includes choking, which is what this says, or kicking, punching, or slapping. And apparently the reason all this, he brought toys into the bathroom, into the bathtub. That's what this says. Well, choking, when you choke somebody, there's only one reason you do that, and that's to seriously injure or kill somebody. I mean, that kills people when you shut off their breathing. They have to breathe to live. So,
Judge, along with the parenting classes, we've also, I think, included the part of the conditions of probation will be that she'll have to attend and complete an anger management program, which I think will further help.
all right, anything else, Dan?
No, Judge.
Where's the child now?
He's living with his maternal grandmother.
Well, what's the,
And
there's the law?
and she's been doing supervised visitations per your order earlier, so they're still having contact.
Has family courts gotten involved into any of this?
CPS has cleared everything and she's done everything that's been required of her, which is all of the circumstances going into the decision for this resolution today.
I guess something like this won't be repeated, huh?
No.
Nothing. And you were pleading guilty voluntarily and because you were guilty in this? Is that correct?
Yes.
Is that yes? Okay. If nothing further, I'm going to make the following findings: that the defendant is pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation. There are a lot of them, but most of these are terms and conditions of probation that all of us, that are terms of life that we all have to follow, beginning with don't commit an offense, avoid injurious, vicious habits, don't associate with disreputable people. These are all good ideas for everybody, but you're going to be required to follow these. They've also completed anger management program
You're welcome.
that will be supervised by the probation office. This will be for 10 years. You do well, it can be shortened to 1/3 of this. There is no fine.
There's a $500
It's $500. There it is. Once you slip $500 fine, the probation officer is going to go over these probation terms, make sure you understand them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. So it's serious, and this can be shortened soon. Now, how many children?
We have no child.
Here it is. Please see the probation officer and begin probation. Thank
Thank you,
you.
Joe.
Judge Stevens deferred the finding of guilt, placing Gage on 10 years of probation with mandatory anger management and a $500 fine. In Texas, deferred adjudication means no formal conviction enters the record, but any violation of probation brings her back before the court, where the full range of punishment for a third-degree felony becomes available to 10 years in prison and a fine of up to $10,000. Deferred adjudication also remains visible on background checks, meaning the consequences follow her even without a formal conviction. The child remains with his maternal grandmother under supervised visitation. 10 years of compliance is what stands between Gage and a felony conviction on her permanent record.